I think it would be helpful for me first to lay out where the estate's at and why we
Yeah.
filed the petition. And then from that point, we can let Ms. Folks and Mr. Renshaw argue before the court. So I apologize, but I think there does need to be quite a bit of facts laid out for this once. So
Okay.
please bear with me with story time. Status of the estate is as follows. We have filed an inventory with the court. It has been distributed to the beneficiaries. We have prepared an interim accounting and have distributed that to the heirs as well. Mind you that there's no requirement to furnish an accounting except petitioned by the beneficiaries 1 year after appointment. So this is exceptionally early. And notice to creditors has expired, so no creditors can file claims against the estate at this point. So the reason why this petition got filed is Ms. Karen, the decedent. She ended up doing some maneuvering with the assistance of her brother prior to her death. There were funds held at Continental Investors account that she had her brother go and liquidate. And the brother distributed the funds to his account, which he then distributed to both Tiffany and Kaylee Sherman. And I apologize for using first names. I just think
Yeah,
last names are all the same, so it's going to be helpful to go on a first name basis here.
I think that is helpful.
Okay. With all due respect, as always, we've distributed those. Excuse me, Mr. Ovenen distributed those funds to the beneficiaries, and then shortly thereafter, Karen Sherman died, and essentially all the financial accounts were drained at that point because.
And was it a day?
It's
Was it
within
1 day?
Yes, it's within a
Okay.
day. So again, we're
Okay.
back in law school where we have these random
Yeah.
damn questions. So we've got a day difference here, and we basically have no cash in the estate because the Longshore Credit Union account had pay on death beneficiaries, which the statute does identify that as a specific bequest. So essentially, we are stuck having a probate for just to distribute a house that was also a specific bequest. The house is not underwater, so we clearly have a solvent estate. And so at this point, my client just would like to have court permission to distribute the only asset in the estate to the named beneficiary, and we can close this thing out.
And that is the house to Gregory Sherman, is that right?
Yes, in his personal capacity. I will note the reason why this is a petition for redemption is that it is not abatement, because abatement only will occur when there are creditor claims filed against the estate. And so the only administration expenses at this point are my attorney's fees and then taking care of the property, as well as filing a tax return for the decedent, which all of that has now been completed. And so at this point, we have expenses. If you had after reviewing the accounting, you see that my client actually is owed to the estate $11,000 for costs advanced to the estate. And so at this point, we just need to distribute this house and close. I do have concerns with Mr. Renshaw's pleadings that my client has breached fiduciary duties. No such thing has occurred. He held the house and the estate so that we could have court permission for anything to act, and he's gone to the court with caution on how he's proceeded with everything he has done in this matter. I think that is a completely unmerited argument, and not only that, it's not even properly filed in this case.
Okay. Thank you. I think, Ms. Folks, if I understand it correctly, you represent Mr. Sherman in his capacity as beneficiary rather than personal representative. Is that right?
That's correct, Your Honor.
Okay, I'll have you go next.
I mean, just piggybacking off of what Mr. Ron said, it's clear that the cash in this estate is non-existent, and that these gifts to Kaylee and Tiffany, as well as there was the Lundgrens, are deemed by either extinction and or satisfaction. If not, then we're of the opinion that the decedent satisfied a portion of those bequests, and that if the court is not so inclined to determine that these gifts to Kaylee and Tiffany are deemed by extinction and or satisfaction, then that they were partially funded and that they would only be owed the amount or less than, or sorry, $30,000 each in that regard. I know there was also some question about the declaration of Michael Ovenen and whether or not that was barred by the dead man statute, which I would disagree, because this is not a matter of a contribution of a non-probate asset. Mr. Ovenen only received an asset via a POD account. We're not asking him to contribute anything, therefore he has nothing to gain here. And so the intent has to come essentially from what everybody said, that these two individuals received some funds and that the intention of the decedent was to avoid probate and for them to have the money as soon as possible, i.e. a day or so before she died. So again, I am in agreement with Mr. Ron that these bequests, excuse me, are deemed by extinction and or satisfaction, and that also Mr. Onven's declaration is not barred by the dead man statute.
Okay. All right, Mr. Renshaw, would you like to go?
Yes, Your Honor, thank you. I appreciate Mr. Ron's recitation of the facts. They were certainly outlined clearly in the pleadings. What we have here before the court is not a request for any abatement. So the categorization of the bequests to Tiffany and Kaylee, I am here on behalf of Tiffany and Kaylee. Kaylee is present on Zoom. Tiffany is not. I am not representing the Lundgrens, although they're swept up in this net of efforts to deem. What we have here is a request that the court find that there has been an redemption, either by extinction or by satisfaction, of the bequest to the Shermans, Tiffany and Kaylee, in the will. We would submit that on the evidence before the court and the record before the court, they have not met the clear intention hurdle to show that indeed Karen's intention was that the $70,000 that didn't come from her, but actually came from Michael Ovenen, were not to either extinguish or satisfy the bequests in the will. And I would submit that we submitted contemporaneous messages between Karen herself and Kaylee indicating, and there were no indicating that the $70,000 was coming, but virtually no mention whatsoever that was intended to be an advance, which has been suggested on their gift in the will, or a satisfaction of the gifts identified in the will. And she certainly could have, and certainly seemingly had the mental capacity to make some decisions in that regard, because she made the decision to allegedly liquidate the Continental Investors account and provide funds to Mr. Ovenen with instructions to distribute. I would submit that Mr. Ovenen's opinion that it was quote unquote to avoid probate is unsupported by any objective evidence than his own words. So I would submit that the request to deem and virtually essentially eliminate all other beneficiaries except for Mr. Sherman, Greg Sherman, have not been satisfied under the principles in Franks and other cases that have been cited by the parties. I would also note that while I appreciate Mr. Ron being uncomfortable with my representation that potentially Mr. Sherman, his client, Greg Sherman, breached a fiduciary duty, certainly the law is clear. He's got a fiduciary obligation to all of the beneficiaries to administer the estate in a way that services them all. But he's conflicted in this instance because also the way in which he's managing this estate feathers his own nest. In other words, he ends up being the sole taker of a piece of property, which, as the court probably saw in the inventory, is worth $1.2 million. It is a substantial asset in this case. And I would remark, Your Honor, and I appreciate, again, Mr. Ron providing some of the materials that he did on my request. He certainly identified for me the correct statute, that I wouldn't be entitled to an accounting until 1 year and those sorts of things. And he did provide some information. But one of the documents he did file, and I received a copy of it on Monday, and he filed it on the 23rd, but I didn't receive it until Monday, too soon to bring it before the court. But I would note that this redemption strategy by Greg Sherman began and was hatched even before the probate was filed. There are entries from Mr. Ron in his billing records that show that there was a discussion for a plan to deal with the specific requests on October 15th. And on October 23rd of 2025, Mr. Ron began legal research regarding redemption. So even before, and that's many months before the inventory was filed, and many months before Mr. Sherman, Greg Sherman, would have embarked on his fiduciary duties to administer the estate and determine if it can be administered in a way that benefits all of the beneficiaries, not just himself. So I would submit, Your Honor, and I would ask that the court deny the petition to deem, in essence, disinherit Kaylee Sherman and Tiffany Sherman. And if the court is so inclined and is unsure, given the factual record here, I'd ask the court to reserve on a decision so that we can consider filing a tender position to expand our ability to get some discovery with regard to some concerning transactions regarding the estate of Karen Sherman while she was alive. And as we've noted, the time frame between the Continental Investors liquidation and being given to Mr. Ovenen, Mr. Ovenen writing all the checks, this all occurred within days, if not hours, before Ms. Sherman finally passed. So we would respectfully request that the court deny the petition for redemption and allow us to move forward. I would also note just that a highlight that Mr. Ron also said, this is not an abatement proceeding. And what's interesting about the discussion about abatement is that if Mr. Ron's characterization of Tiffany and Kaylee Sherman's bequests as being specific bequests, and then Mr. Sherman, Greg Sherman's bequest of the real property is also a specific request, they all three are entitled to the same level of protection under the abatement statute cited by both counsel, 110, which means that they, in that class, they would all need to abate in a proportionate situation here. And what is being suggested by this petition for redemption is that Tiffany and Kaylee's and the Lundgrens as well, if they are specific requests, that they be abated to 100%, and Greg Sherman, his specific bequest of the real property, not abate at all, which I don't think is what was contemplated by the subsection 1 of the abatement statute. But I would also note that subsection 2 of the abatement statute on 110 does allow the court to deviate from the statutory hierarchy of abatement if to do so would be in keeping with the testamentary intent of the decedent. And we would submit that the will on its face and the evidentiary record before the court would suggest that the decedent had a very different testamentary intent than to simply disinherit everybody but Greg Sherman, and that Greg Sherman walk away with a piece of real property worth $1.2 million.
Thank you. Mr. Ron, anything in rebuttal?
Yeah, so there's a few things. I guess the first thing I want to address is what Mr. Renshaw said about my legal research. Good attorneys do their homework early. That was from the first meeting. We always take an asset inventory of the estate to get an idea of what's in the estate. And that was the first thing that came up was, what is in this estate? There's a house. I go, well, what about financial accounts? There's a bank account. Okay, well, do those have beneficiaries? Okay, we check that box. Were there any investment accounts? They said there was a Continental Investors account that got liquidated. And I realized right then and there, hey, where did that money go? And then that explanation was given. This whole thing with Kaylee and Tiffany Sherman was at the very get-go in that first consult meeting that we had. And from the get-go, we knew we were gonna have to deal with it, so we had to figure out how we were gonna cite this to the law and apply the rules. And so we did extensive research on both abatement and redemption, so we knew what we were actually talking about. Again, why I keep telling the court this is not an redemption issue, or excuse me, not an abatement issue, excuse me. It is only an abatement issue if a creditor claim were to be filed against the estate and it were to demolish the remainder share, and then we needed to go into specific bequests. So we clearly see that we do not have that at bar here. So we can just strike abatement out as any category that this hearing pertains to. That leaves us with redemption because we have missing assets. They would be treated as there's no cash and there's a specific bequest of a real piece of real property that would flow to the named beneficiary under the will. And so I would argue that Mr. Renshaw's site has no citations to change that decision. And I think the court is in a perfect position today to make a decision to say that we have redemption at this issue, whether by extinction or by partial satisfaction. I would also go to saying that, yes, Mr. Judge Evans, what's he doing?
Oh, he's stepping on. I do have to get to civil docket, and he's stepping on for that first one.
My apologies.
Nope, you're fine.
Okay, well, Judge Evans threw me off now.
Yeah.
So we
No, you're fine.
we have easily a court able to make a decision as to redemption. Mr. Ovenen's declaration is not barred by the dead man statute. This is not a transaction where he had anything to gain from decedent in this situation. He's merely saying what happened. And we go to the declarations of both Kaylee and Tiffany Sherman, and they show grandma sent them cashier's checks and they need to cash them quickly. And so whatever that means is clearly Michael Ovenen sent them money on behalf of grandma. I mean, there's nothing else you
Let me ask this, and I know you've mentioned law school a few times, and one of the things, right, they talked about in law school is, does it pass the smell test? And here's what I'm having difficulty, and maybe I'm misreading this, so please correct me if I'm wrong. But in the account that was liquidated just prior to passing, it looks like, let's say that hadn't happened, that money hadn't transferred out of those accounts, that Longshore account is a non-probate asset, and it has two people listed to split it, and that's Greg and Michael. Right? So it seems there is a question in my mind then of, did Greg and or Michael realize if this stayed here and they get this money, then there isn't anything in the non-probate asset to give Kaylee and others, and then they would have to dip into the home. So were they a part of this to protect the home?
So, Your Honor, to answer that is it's a specific bequest for the home. Had the home been a remainder asset, then the answer to that question would have been yes. But because the home is the first specific bequest on the chain in the will, the house goes to Greg Sherman in his personal capacity. So my position on it, and by the way, just taking the step back, in a perfect world, none of that stuff would have happened before Karen. I'm just saying that right now would make my life.
Understood.
You know, but in this situation, the house still goes to Greg Sherman. This position, and again, Mr. Renshaw cites nothing in his briefing that shows why there would be the sale of the real property to satisfy all these specific bequests that are in cash.
I don't think he talked about sale necessarily. He referenced, and I'll give Mr. Renshaw a chance to speak, but that the PR can encumber or in some way get cash flow from the property. So I guess, Mr. Renshaw, let me hear from you if you want to answer the question about if nothing had happened, if the money hadn't transferred, it'd be split between Greg and Michael. And then where are we?
Your Honor, I'm sorry, I know you just asked Mr. Renshaw, but I think I didn't answer your question fully. The Continental Investors account would have been ported had it not been liquidated. That should have been ported into the estate bank account. That money would have been first used to pay for administration expenses. That then would have been prorated as specific bequests to the beneficiaries. And arguably, I mean, you would probably say cash wise, you would go by that priority on the will. So I think the 100,000 each goes to Kaylee and Tiffany. So you probably would do some sort of mathematical formula to prorate that after we know the expenses are paid.
Okay. I had it listed in, and maybe it was in an early filing, that it was a non-probate asset, so it would not have gone into the estate.
The Longshore Credit Union account was a non-probate asset, Your Honor.
Okay.
So
Okay.
there's cash at Longshore Credit Union that had non-probate those had pay on death beneficiaries. The Continental Investors account, to the best of my knowledge, did not have pay on death beneficiaries. I
Okay.
could be wrong, but I never saw a beneficiary designation on it.
Okay, that is helpful. Thank you. I do have to kind of wrap this up here shortly, because we have a 2 o'clock docket that started 5 minutes ago. But Mr. Renshaw, did you want to make any further argument?
Well, Your Honor, I just wanted to seize on what you said. If it doesn't, if it doesn't pass the smell test, and I certainly would say that on the evidentiary record here, this doesn't pass the smell test. We've got a very, very near death movement of some money, liquidation by the decedent given to her brother. Why that? If the decedent wanted to make a satisfaction, she could have written those checks or transferred that money to Tiffany and Kaylee directly rather than giving it to Mr. Ovenen, who then is now post hoc saying, well, this is what she told me without any verification of that. I would agree with Mr. Ron's assessment that if we don't have any visibility, we've not been provided visibility on the nature of the Continental Investors account. Assuming it was not a POD account, then that would have been ported into the estate. What we don't know is, were there other assets that were also moved around right before death? Mr. Ovenen certainly was involved in that process right before death, that could have also been ported in. Secondly, I would note that there is the authority for the PR to encumber the property necessary for the administration of the estate. Mr. Ron is correct. I didn't cite any authority on that because, quite frankly, I can't find any direct authority that says he must encumber a $1.2 million piece of property to generate the liquidity to service the other monetary gifts in a will. But nevertheless, there's a reason why the law gives, not only the law, statute, but the will gives him the authority to do so. And we would submit that that he has the authority to generate the liquidity out of the estate to meet the obligations of the monetary gifts within the will before it then gets administered in that way. And that's his role as a PR. And I think the fact that we're having this conversation highlights the significant conflict of interest here and the tension that we have between Greg Sherman as the PR and what his statutory obligations are to the beneficiaries, and Greg Sherman is the beneficiary who's looking to to inherit a piece of property unencumbered for $1.2 million. So we again would ask that the court deny the redemption petition or at best reserve and allow for a tender petition to be filed so that a greater evidentiary investigation can be done into what really happened in the waning hours and days of the decedent's life and why. And I would just note, as a quick aside, $140,500 got moved from Continental Investment to Mr. Ovenen's account. If all of that money was intended to satisfy, then why did Mr. Ovenen retain $500 of that? There's no discussion, and Mr. Ovenen doesn't address this in his declaration, saying the decedent said, give 140 of this to Kaylee and Tiffany, and you keep the 500 for your troubles. So we have again, it just doesn't pass the smell test. And I would ask that the court deny the redemption, one, because they don't meet the statutory standards to have an redemption by satisfaction or extinction, or at least reserve, and allow us leave on behalf of the Shermans to file a tender petition to look at this with a brighter light and a finer tooth comb.
Ms. Folks, anything further?
I will keep it very brief, Your Honor. I continue to go back to the intent of the decedent. I think that the fact that her credit union account was payable on death to Gregory and Michael was probably an indicator as to why she did not put that money in her own bank account, because then it would have gone to Gregory and Michael Instead, she gave it to Michael and said, give it to the girls because I want them to have it now. I think that there's
Well,
also,
I do think dead man statute plays here. So if, I mean, this is exactly what the dead man statute was aimed at, is we can't bring in things that people who can no longer be cross-examined about can say. So I understand the argument, but my hands are, I cannot make a finding that that was her intent based on what a third party says a now deceased person said.
okay. Well, again, then I would just, again, alternatively ask that the court determine that these bequests or these gifts to Kaylee and Tiffany were advancements in accordance with RCW 11040441.
Okay.
Thank you.
And yeah, thank you. And Mr. Ron, as the moving party, I'll give you the final word, and then I will take this under advisement and get Judge Evans set up for his next docket.
Okay, so I guess briefly, Your Honor, I will just say that Mr. Renshaw's argument to encumber a property that is a specific bequest for the benefit of his client would then be to the detriment of another beneficiary, versus we clearly can tell they got the money, at least a partial portion of it. I would just say that a TEDRA petition in this scenario, we've already filed the interim accounting, the inventory. The court clearly knows what's in the estate, which is a house. We're already in the negative. So Greg Sherman personally is having to pay all estate administration expenses. I think a TEDRA petition would, number one, be a gross misspent amount of money. Two, it would be a waste of court time and resources, when clearly before the court is we have a house that just needs to be distributed in the state that can be closed. I think if there's other questions Mr. Renshaw has, it has to do with a third party that is the declarant, Michael Ovenen. It has nothing to do with Greg Sherman as the PR of the estate. I think the estate is ready to be closed at this point, and I would ask the court, taking under advisement, to find that there has been a redemption. We can distribute this piece of property and we can close the estate.
Okay. So just in the interest of time and frankly, some more written research and a written decision that an aggrieved party can further have reviewed, I will get a decision to you within 30 days. I like to set deadlines now for myself, otherwise then it doesn't happen. So I'm going to get a decision to you within 30 days. I understand some things may be filed between now and then. If any discussions between the parties, resolutions or other filings necessitate an interim hearing that could potentially impact my decision, we could get that noted on quickly. So please reach out to court admin and let me know if that occurs. Otherwise, I'll consider the hearing concluded. I'll get you a decision, and I think we can end docket and get Judge Evans going on his.
Thank you for the time, Your Honor.
Yeah, thank you. Thank you all.